Welcome to FO Talks. My name is Anton Schaubel. I'm Fair Observer's Chief of Staff. Which with me is Andrew Morrow, an Arizona lawyer and former administrative law judge. Welcome, Andrew.
Thank you. Happy to be here.
On Friday, June 24th, in a 6-3 decision, the U.S. Supreme Court overturned the Chevron defense doctrine in the decision Loper Bright Enterprises versus Raimondo. The doctrine was named after the 1984 case Chevron USA Incorporated versus Natural Resources Defense Council Incorporated. Why don't we start by giving a little bit of background? Andrew, could you explain to us what was decided in the original Chevron decision and what motivated it?
Sure. Okay. So it's hard to talk about Chevron at all without talking about what I and a lot of other people call the administrative state, which
All right.
is the group of administrative agencies organized under the executive branch of the US government that executes the laws written by Congress. So things like the Department of Labor, Department of Justice, even. The Department of Justice, despite being called justice, is not a part of the judiciary, it's part of the executive. The Department of Agriculture, Department of Transportation, all of these, the EPA, which is what was at issue in Chevron, all of these agencies are organized by the executive department. And this has gone on for a very long time, but it mostly went back to FDR, Franklin Delano Roosevelt, who organized the administrative state as we currently know it. And it is the bureaucracy of the American government. So it's hard to talk about this at all without knowing that's what we're talking about, the administration, the bureaucracy's decision making ability, and how much deference a judiciary court has to give the decisions of the administration. So in Chevron, the very long story short was Chevron, the oil company, wanted to get a sweetheart deal from the EPA on a lot of the regulations that govern them. So, despite Chevron being technically decided in favor of the government, it actually really benefited a private company very much because the EPA gave Chevron a lot of deference and a lot of latitude in the EPA's interpretation of the regulations that governed the Chevron oil company and their air filters. That's what it was about. So the decision, because that's all we really care about, we don't really care about what Chevron did these days, is that when somebody wants to challenge the decision of a governmental agency, unless the law is explicitly clear, a court must defer to an agency's interpretation of their own rules. So if the EPA decides that a filter means a piece of, a coffee filter, okay, that's the EPA's understanding of filter. If the EPA also thinks that a filter means you putting a rag over something, well, that's the EPA's decision, that's their determination of a filter, and a court is not going to contradict the EPA's decision on what is and is not a filter. So that was the world. Now, it's important to know that this decision is younger than many of the people who are probably watching this. This decision is only 6 years older than I am. It is not ancient law. It does not stretch back to the Roman times or Anglo Saxon law. It was created in the 80s, and it was created for a very specific purpose, which was that at the time, the court did not want to hamstring the administrative agencies with questions all the time about what they were doing when they executed their regulations. Because a rule created by an administrative department is a law. It may not have as much weight that we give a court decision or a statute enacted by Congress in our minds, but It's a law as much as anything else because if you defy it, the government can and will hurt you for it. So that's a law. Now, at the time, Chevron came and went with barely a whimper. Nobody really paid any attention to it at the time. And it was generally considered to be one of those very narrow decisions that was applicable to those two parties, and then nobody else would ever pay attention to it again. However, an interesting thing started to happen a couple years later. The lower courts kept citing it in motions to dismiss. Somebody would have a problem with an agency's decision. They would file suit in court thinking that, hey, it's the court's job to decide who did something wrong. And then the agency would motion to dismiss the suit, saying, hey, court, you can't really question our decision because this Supreme Court case said you have to give us incredible deference of our interpretation of our own rules. And the jurisprudence of Chevron defense developed very strongly quickly, but much later than when the decision was actually enacted. It was not cited right away. So that sort of evolved. It evolved over the last 40 years since then. And it's made a lot of people very angry because you think, oh, well, I don't like what the government did. I think they made the wrong decision. I'm going to sue them. And you sue the Department of Labor or the SEC or the Department of Agriculture saying, no, Department of Agriculture, a cow does not mean a chicken. It does not mean, it means a cow. And then, the Department of Agriculture would motion to dismiss your suit saying, court, our internal regulations define a cow and it defines it as whatever. I'm making this up as I go, but whatever. And if a chicken falls into that, hey, it's a cow as far as we're concerned, and you can't question it. And the court would say, yes, Chevron deference means we have to defer to you. Dismissed. And that obviously makes a lot of people very angry. And it specifically made Supreme Justice Gorsuch very angry. Justice Gorsuch has had a significant and very intense hatred for the administrative state and Chevron defense deference for a very long time. And even though this decision on Friday was not written by Gorsuch and he wrote his concurrence, in the main opinion, it's a Gorsuch opinion. It's got his fingerprints on it. It is his brainchild. It was just written by somebody else because he wanted to make a very narrow point in his concurrence, which we can get to later. But that
So
is
before we get on to Loper Bright, let's talk a bit about the time in between.
sure.
How
So
did Chevron come to be a partisan issue?
it became a partisan issue because who controls the agencies? That's why it's a partisan issue, and who controls the judiciary? The agencies, the federal bureaucracy is heavily staffed by political appointees, and political appointees are products of the administration that appointed them. And at the time of Chevron, I believe it was still Reagan, but then that went into Bush 1, and Bush 1 gave way to Clinton, who had control of the agencies for the entirety of the 90s effectively, and then went into W2. And everybody involved in that was more or less on the same page with regards to federal power. Federal power being a thing that you like if you are in the federal government, whether or not you have an R or a D next to your name. If you're part of the government, you like federal power. So there was always an incentive to expand the agency's authority. You know, W2 created the Department of Homeland Security, who people now can't go anywhere without checking in with, really. So this is not just a Democrat thing. It's not just a Republican thing. It's the feds thing. So the federal bureaucracy is staffed by career bureaucrats who may as well be apolitical in the sense that they don't particularly care whether the elected official above them has an R or a D next to their name. Their power is what they are concerned with. And their power was heavily insulated by Chevron deference because they could make a decision and just thumb their nose at any challenger in the courts, provided that the law was not explicitly clear, and laws are almost never explicitly clear. So that caveat rarely played into things. So the bureaucracy was always interested in expanding its own power and authority, and that became a partisan issue over time because the judiciary is much less like that. The judiciary has a lot of, we would call it soft power, we'd call it symbolic power, we would call it customary power. When a judge issues an order, it's not a magic wand. If I'm a lawyer in my private practice, I tell my clients all the time, hey, we could win a judgment for $1 billion and it doesn't put the money in your bank account. An order from a judge is not a magic wand. It needs to be enforced. And the people who are charged with enforcing it are executive agencies. So your sheriff department, your local sheriff department, and if a judge issued an order telling an agency to do something other than what they did, if they just refused or if they shuffled into a stack of paperwork and said we'll get to it later and never gotten to it, nobody really holds them accountable for that because the judiciary doesn't have men at arms for them to enact their will. Even a bailiff in a courtroom who would listen to a judge, he is not the judge's employee. He's a sheriff deputy or a U.S. marshal or something in the federal circuits. He is an executive agent. So the judiciary doesn't like or has shied away from the federal bureaucracy's ability to just thumb their noses at their orders. And that's how it sort of became a partisan issue. Because, and when I say partisan, I don't specifically mean R or D. I mean advocate of federal power, advocate of reducing federal power. Because there have been uh, liberal justices on the courts who have really taken problem with Chevron because when an agency, like in the original case, benefited Chevron the company, progressive justices have not really liked that, but they've still gone with Chevron deference and said, well, we can't really pry. So it became a partisan issue over that time. And the courts
I see.
have.
So you're saying, if I can interrupt you for a second, you're saying that the courts have a vested interest in preventing the expansion of the authority of the executive branch because it decreases their own authority to make decisions. But the Supreme Court stepped into a legal territory that it wasn't expecting to step into when it decided Chevron originally, and
I would think
eventually it would roll things back.
Yes, I would think that they did not originally intend on stepping into this wide latitude because there is the Administrative Procedures Act, which is the statute that enacted the original authority of the administrative agencies to do things. And the majority opinion really spends a lot of time on that of saying, hey, there is a body of statutory law here that everybody can look to. We don't have to just take their word for it. If the Administrative
And the
Procedures
Administrative
Act,
Procedures Act, what year was that
the
enacted?
original, the year itself escapes me right now, but the original one that created administrative procedures, and that sounds tautological, but a lot of a lot of laws are an act to do X, and the act does X.
At least it was some period of time before Chevron. That's the important
Oh,
part.
significantly, at least 40
Yes.
years before that. Yeah. So things were chugging along up to Chevron with you being able to challenge a court's decision in the court, not a court's, an agency's decision in the courts, and there'd be lawsuits about it, and some would win, some would lose, but then Chevron was a watershed moment in favor of the administrative state's ability to just say, you can't touch our decision. We've made it. You defer to us, and that was that's where we've been from there. And then so Chevron has been narrowed and clarified. We say the word clarified when we mean an exception created. Clarification makes it seem like the exception was always there and we just discovered it. No. When a law is clarified, a court says, maybe they didn't quite make a mistake, but they overlooked a little something. So we're going to clarify things and make a new rule. So Chevron had been clarified significantly since its original instantiation. And in fact, the court itself had not used Chevron deference to make a statement since 2016 or 2017, one of the two. So it's been several years since there was a Chevron case before the court at all. And the last one was a narrowing, an exception, a clarification that reduced Chevron authority. So this decision was long coming. And the reason why it came now, in my opinion, is because the perfect case came along to do that. Because, and this is something your listeners and your readers may not quite understand, but in order for courts to decide anything, you have to have what's called a case or controversy. The Constitution itself has a clause in it called the case or controversy clause, which means that a court cannot just be asked for an opinion. You cannot just petition the court to do something. You have to have a dispute with somebody. And this means that cases that reach the Supreme Court are very narrowly tailored to attack specific laws. Like a couple, it was 2 years ago or last year, the Dobbs decision that undid Roe v. Wade. The only reason that ever reached the Supreme Court is because the legislature of Mississippi, I think it was Mississippi, it was one of the states in the Deep South, created a law that specifically and very narrowly defied the Roe standard because they knew they'd get sued over it by the ACLU or whoever, and then that would work its way up the ladder of one side going yes, one side going no, and then when it reached the Supreme Court, there was a very narrow issue before the Supreme Court at that time of, is Roe constitutional? And we had that very same issue with Loper v. Bright, which is the court case that was decided last Friday. Because the court didn't actually even decide anything relevant to the parties in Loper v. Bright. Now, they did, of course, because they undid Chevron deference, which will inform the lower courts of how to take things from there. But they didn't say, you win, you lose. Supreme Courts almost never have decisions like that. The Supreme Court and most courts of appeals issue orders that say, such and such is decided. This matter is remanded to the lower court for further proceedings consistent with this decision. And that's the language that,
on appeal, just to clarify some particular point of law, and then the case itself, the dispute between two individual parties, will be decided again later.
Correct, because appellate courts are not what we call fact finders. A fact finder decides the truth. Usually people think of this as a jury, but a judge can be a fact finder too. And a fact finder means that when one side tells their story, the other side tells their story, the judge says, I believe you, that's what I'm deciding, and goes with them. The judge finds the facts that favor that side, or the jury. I'm just being short here. But a fact finder decides factual issues, and you can disagree with them, but they decide what the facts are. Courts of appeals, all the way up to the Supreme Court, do not touch facts. Almost never. There's always exceptions, but almost never. They decide questions of law. If this then that, right? That'd be a question for for a court of appeals, because the fact finder decides this and that, but the court of appeals decides the logic in between of this then that. Well, the court of appeals may say, well, no, not really this then that, this then the other thing. But the this is not undone by the court of appeals. So when the Supreme Court issued their decision, they remanded the decision to the lower court for further proceedings consistent with that decision, which probably means that Loper is going to win, right? But it's not quite done. So
Mhm.
the decision in Loper v. Wright and why it was very narrowly tailored, it's an interesting fact pattern because it highlights how this bloat of federal regulation came about. So Loper is a herring fisherman or a company of herring fishermen. And under the agency that administers fishermen, they are required to have a third party monitor on their boats at all times who is not an employee of the fishermen, not an employee of the agency. They're a third party monitor. Now, for a very long time, those monitors were paid by the government. Then the government ran out of money and the agency decided that a new regulation they would promulgate that said, no, herring fishermen, we're not going to cut them their checks anymore. You are. So these third party monitors were installed on boats going out to sea to fish by the US government, and the government made the fishermen pay for them. And these monitors very often were the most highly paid person on the boat. Many of them were paid more than captains, especially if the haul of fish was not that great. So this process, and they were paid per day. Okay, so that they were not salaried; they're paid per day. So I think I saw that one of them was paid $700. So $700 per day. So 10 days they're out there, they make bank, right? And the boat may not, but the boat pays for them. So the fishermen were obviously very upset about this, and they sued the agency. And they sued the agency in such a way that their lawsuit was crafted to run afoul of Chevron deference because they knew that the initial courts and the courts of appeals would say, well, Chevron deference means the agency decides who pays. We got to go to that and dismiss. And then they'd appeal, and the next court up would do much the same, and they'd get dismissed and they'd appeal. And it reached the Supreme Court, and it reached the Supreme Court with a very narrowly tailored question for the Supremes of is Chevron deference valid? And the Supreme Court answered no. They answered Supreme Court. They answered no, 6-3. It was, I would call it an ideological split, but I would not call it an R or D split. It it comes down to the ideological decision of who does the court value the opinion of more, lower courts or the administrative state. And as I mentioned, Gorsuch doesn't like it, Alito doesn't like it, Thomas doesn't like it, and that's the ideological core that really shifted the majority around themselves.
Not necessarily all six of the members of the majority were voting because of ideological textualist
Correct.
motivations.
We've had this talk before in just our friend groups, but in my opinion, Justice, uh, the Chief Justice, Roberts. Roberts is not an ideological partisan for anybody except the court. His first and foremost duty in his mind is to the legitimacy of the court. And what this means in practice is he pisses off everybody equally. You know, he sets out to make everybody mad in equal measures so that nobody is mad enough to join forces and take the court down. Because, yeah, he decided against you today, but he decides against the other guy tomorrow, and maybe he'll go for us the next day. So why should we rock the boat? That's his primary goal, is to not rock the boat. So but he definitely seems to, he joined, right? He didn't write an opinion, so we don't know his full thoughts. He just signed his name to the majority. Oh no, Roberts did write the majority opinion. Well, he wrote that then to be the middle of the road peacemaker. But
Mhm.
as I mentioned earlier, it's Gorsuch's logic.
It often happens that the moral author of an opinion is not the same person as the literal author of an opinion.
Correct. And we saw that in Dobbs too, because there was that leaked draft by a different judge. And then the majority opinion was written by a different person than who wrote the draft. But the draft and the majority opinion were very, very similar. So you know that somebody else did the final work on it and they got their name on it, but the kernel of the case was somebody else's. And
So
we
barring
did.
a leak, we won't know as certainly as we do in that case, but we can make a educated guess that Neil Gorsuch, who's had a chip on his shoulder against Chevron for some time, was involved heavily.
Correct. That is my opinion. As you said, barring a leak like the one in Dobbs, which I don't think will happen because we're well past that, and we're well past the decision, and it's not as earth shattering. Actually, no, it is. It's probably more earth shaking than Dobbs was. And but we will not feel those aftershocks for quite a while.
So it is very easy to say what the impact of Dobbs is. It's about abortion, gets implemented very quickly. The public is aware of what the issue is very distinctly. In this case, we have something that's more of an abstract general issue where the particular effects of it will take some time to percolate through the legal system.
Correct, because Loper v. Bright is not retroactive. The Supremes did not go line by line through the U.S. Code. That would have been a 50,000 page opinion. So we're fine with that. But they did not go line by line through the U.S. Code or the list of departments and agencies and do like you saw that video of Javier Milei, president of Argentina, going afuera, afuera, afuera to different agencies of the government with him to say you're out, you're out, you're out. Well, the Supremes did not do that. They did not make it retroactive. They did not disestablish agencies in their opinion. But a second opinion that happened a couple days, more or less the same time, or it might have been Monday of this week, um, removed the statute of limitations on challenges to federal agency decisions. So
Mhm.
you can now challenge an agency decision from 30 years ago that maybe nobody has had a case about since then. So
So now
I
everything is
expect
on the table. There's a
everything's on the table.
massive amount of decisions that could be reversed.
I fully expect the next 6 months to a year to see tens of thousands of ideological lawsuits of very targeted plaintiffs challenging very targeted administrative decisions. Because, if you look at any code, you will find rules that you have probably broken. There is a rather famous book called Three Felonies a Day from 20 years ago, I think, that put together the case that the average American commits 3 felonies a day based on the bloat of the administrative code. Because remember, all of these codes and rules are laws. Just, they're not as strong in some ways as statutes, but they are laws still. So
And they're
if you
capable
break
of creating felonies.
some of them, because because then there's a statute that says a violation of a code of this agency is equal to yada yada yada.
Mhm.
A clerk in the Department of Transportation isn't writing felonies, but he's writing rules that the statute that enacted the Department of Transportation treats as felonies if you break them. So
Right.
it's recursive in that way. But so you've probably broken a felony today and you didn't even know it just because the code was so bloated. But now we're going to have people going through and finding felonies to break in the administrative code, in the various rules and statutes that created these agencies, and they're going to get dinged or they're not going to get dinged, and they're going to challenge those as being wrong, right? Remember, because a lot of this is not challenges of, well, no, I didn't do it. It's challenges of, yeah, I did it, and the rule is bad, those are very different types of legal challenge, right? If I get indicted for murder, I can present a defense of you got the wrong guy, or I can present the defense of I did it and I was justified in doing it. So there's multiple different ways to challenge an administrative code too. You could say, no, I didn't break the rule. You could say, yeah, I did it and the rule's bad. And you can challenge it in that way. And the challenges would be something like it's unconstitutional, or in a variety of different ways, because there's all the sorts of, this is way too much to get into, but there's all the sorts of different uh, statutory interpretation, like rational basis, intermediate basis, strict scrutiny. But that's neither here nor there for this discussion. I'm just saying there are multiple different levels on which you can challenge an administrative regulation. So we would definitely see that coming down the pipeline of people enacting actions that fall afoul of federal regulation so that they can then challenge it in court, like Loper did, and like the Dobbs people did. Dobbs wrote a law that directly contradicted Roe, so that they knew that a year and a half, 2 years down the road, they'd be before the Supremes on the very narrow question. Because a lot of the time, the Supremes can punt very easily. They can say, okay, we'll answer this narrow question, but that means we don't have to answer anything else. And a suit will fail in its intended purpose because the court did not answer the question they actually wanted them to. Well, we've had a court recently that's been very willing to answer the question posed to them, and not punt. And but we've had some punts too, and thanks to Roberts. But again, that's a different sort of discussion.
We don't, this isn't the Indian Supreme Court. It can't answer petitions or make decisions on its own motion. But if
Correct.
you have a determined enough set of legal activists, they can kind of jury rig their own advisory opinion out of a case.
Correct. Because you cannot petition the court for an advisory opinion. And an advisory opinion is when you ask a court, hey, I'm thinking about doing this, but I don't know if it's legal or not. Can you tell me? And we call those safe harbors as well. You ask the court a court ahead of time, hey, give me a decision about how you will rule so I can rely on that. Federal courts don't do that. And they decided not to do that very, very early on because the case or controversy clause limits their authority to cases and controversies. And a question of how I will rule later is not a case or controversy. Now, you can still get advisory opinions in some state courts, okay, because
Mhm.
state courts there are 50 different versions of them, 50 different constitutions. Some are fine with advisory opinions, some aren't. You can probably ask an advisory opinion of an attorney general's office, and that's not law, but it is it's an advisor. It's advisory, and it's usually good to rely on. You can use it as a defense, but it's not ironclad. So the court doesn't issue advisory opinions, and they try to narrowly tailor things. And that means that in order to get an ideological decision in front of them, you got to narrowly tailor your issues as well. Because this is slightly how the sausage is made and not academia. I'm a litigator by trade. I'm a knife fighter. I'm not a scholar. I'm not an academic. So when you appeal, you state your issue. Okay, the court doesn't really determine what the issue is. You, in your filings, state your issue. You give a summary of the facts, but you ask the court a narrow question in your filings. And it's up to them then to say, yes, that is the right question. We're going to answer that one. Sometimes they say, you asked a question, we're not going to answer that one, but we'll answer this one. But you frame the issues because, again, it's not a trial. It is not an open ended body of evidence of what both sides produced in discovery, which is the part of a lawsuit at the trial court level where both sides exchange their evidence. That doesn't happen at the appellate stage. All the evidence has already been produced. So the world is narrowed, and you narrowly ask an appellate court to do something to answer a question based on the record before the court. So you narrowly tailor, they narrowly tailor, and things just get more narrowly tailored the further up the pyramid you go.
So now the gates are open. You've got a country full of lawyers just looking to make their impact and change something.
Yeah. Is this where I pitch our
You'll
firm?
have a lot of attempts at tailoring cases to make changes now that Chevron has been overturned. Is there any particular issue or ruling that you have your eye on?
Well, because I cannot just file a case myself, of course, I need a plaintiff to have a case or controversy. No, I don't have an agency in my sights, but I'm sure that there are people even right now as we speak on this Wednesday afternoon writing those lawsuits because they had their plaintiffs already ready, because a lot
Mhm.
of these a lot of lawfare, which is what we call warfare with the law, is planned in advance. Plaintiffs are manufactured, and this is not a recent phenomenon. I mean, this goes well back. I mean, you probably know that Rosa Parks was not the first black woman who was asked to move her seat on an Atlanta bus, but she was the best plaintiff. There were a couple before her that the civil rights organizations decided not to champion the causes of because they just didn't quite like the case that person brought. Rosa Parks was the plaintiff they sought. So they took her case and they narrowly tailored their case to challenge further up. And I think we'll see a lot of that now. There's probably people who are already in the works, narrowly tailoring their challenges to try to undo this knot of federal regulation that burdens everybody's lives.
I guess we'll just have to wait and see what happens next June.
It's going to be a fun couple years for my profession. I mean, I'm sure it's not a race. It's not that exciting to most people, but for somebody like me who keeps their finger on the pulse of how this stuff goes, it's going to be exciting.
Well, I look forward to watching the fireworks as well. Thank you very much for speaking with us, Andrew.
Well, it's been a pleasure to be here. Happy to talk anytime.
Join the conversation at Fair Observer and subscribe to our YouTube channel.